Okay, we'll go ahead and get started. Again, I'm Kelly McIntosh with Holland & Hart. Thank you for joining us today, either good morning or good afternoon, depending on where you're at. I'm based in our Reno, Nevada office, and we also have offices throughout the Mountain West and in Washington, D.C. Today we're going to be talking about long-term care and recent government changes, specifically going to focus on the CMS facility rules, the condition of participation rules that were issued last fall, and also the OIG's 2017 work plan, and specifically the pieces of its work plan for this year that focus on long-term care facilities. The written materials, which will be sent out following the presentation, include a copy of the presentation, also a copy of the OIG's work plan for 2017, the final rule issued by CMS with the requirements, the conditions of participation changes for long-term care facilities. And these will all be sent electronically. I note that specifically that you may want to keep them in that format because the final rule, for instance, is well over 100 pages. The conditions of participation luckily are not that long, but the final rule is one I have bookmarked because it's, I think, about 180 plus pages if you are to print it out. And finally, the CMS's survey group nursing home action plan for 2016-17. Also, that's a resource that is a little bit more user-friendly in terms of actually implementing things day-to-day than the text of the final rule may be. Just a few preliminaries, as always with our webinars. All of our webinars are recorded and then are available for download on our Holland & Hart Health Law blog, as well as client alerts, upcoming webinars, and other information from our Health Law group. If you have questions, feel free to use the chat line. Usually we run fairly close to time, so more often if you have questions, if you send them through the chat line, I get a summary of those after the call, so can respond to you separately after the call finishes, or feel free to also just drop me an email. My address is there, ksmcintosh@hollandhart.com. And if you have any technical problems during the program, feel free to reach out to Luke Kelly, or again, also keep in mind these are recorded, so you can just check out the recording. Usually they're up within a few days' time after the webinar occurs. And as always, we're just offering an overview of legal issues and considerations in the webinars. Always review your applicable laws. State laws factor in, obviously, to many of the licensing requirements that you as either facilities or providers or folks that work with facilities encounter. So the federal law gives some framework for the legal environment you're in, but also consider your state laws, type of provider, even type of long-term care facility, as well as governing documents and contracts, and especially with some of the issues we're going to be discussing because they are currently changing and being considered in court processes even, and also will be further developed, I think, and discussed in other items promulgated by CMS. Make sure that you're looking at the most recent status of any of these items as well. We're not going to be this program isn't establishing attorney-client privilege, and we're not going to be giving legal advice here. So with those out of the way, we can jump right in. I'm going to start with the OIG work plan because it is more high level of what the Office of the Inspector General for the Department of Health and Human Services is looking at this year, and then go into what CMS issued as its final rule. And I start with that in part because each year the OIG work plan is something that is issued as an annual document for the coming year, and the OIG issues that so that they indicate their focus on new and ongoing reviews and activities that they're going to do with respect to Health and Human Services programs and operations. Doesn't mean that by any stretch that what the OIG calls out as in their work plan is the only thing the OIG is focusing on, but can give good insight for activities that are going to be a specific focus and oftentimes items that are in an OIG work plan in one year help shape rules and regulations and proposed legislation in years following with the information that the OIG gathers during the actions on its work plan. So good to keep in mind, and also just be aware that some of the items that we're going to talk through involve the OIG reviewing and looking at specific facilities activities in certain regards. So there could be facilities out there that are contacted specifically with respect to these activities. And I'm just going to highlight again the OIG work plan covers many different categories of health and human services aspects and coverages and different types of providers. I'm going to talk specifically about those that relate to nursing homes and skilled nursing facilities. The first is the Nursing Home Compliant Investigation Data Brief. This is a new focus, and I'll just highlight that because some of the items here have been discussed in earlier OIG work plan releases. This one is a new item this year, and specifically it talks about the OIG reviewing and determining to what extent state agencies have been investigating nursing home complaints in the required timeframes. The timeframes are currently set as 2 days for immediate jeopardy events and 10 days for actual harm events. There was a previous OIG report that came out in 2006 that found that state agencies were not, in some cases, investigating those these serious levels of complaints within the required timeframes. So they're going to be, I think, updating. I would expect that it'll update their previous work and also see how those timeframes are being implemented on the state level in present time. The next is also a new focus for this year, and that is to focus on unreported incidents of potential abuse and neglect. And this one is specifically discussing that they're going to be looking, the OIG is going to be looking into if reporting was done of potential abuse and neglect in compliance with state and federal requirements. And also we'll be looking at, and the OIG's work plan was specific that they're even going to be interviewing state officials to determine if sampled incidents that they pull out were reported, if reporting would have been required, and further, a step beyond that, if reportable incidents were investigated and subsequently prosecuted, if appropriate. So looking kind of top to bottom through when incidents were reported through potentially the prosecution stage by a state or state agency. The next item in the work plan is also a new focus, and discussing skilled nursing facility reimbursement. So the skilled nursing facilities are required to periodically assess their patients using a tool called the minimum data set that helps classify each patient into the specific resource utilization group that they're appropriate for purposes of payment. The activities of daily living score and therapy minutes and a few different components that go into that are reported in the minimum data set tool, and then get to ultimately the reimbursement tied to those services. Obviously, more care and services provided, the higher the payment would be. So the OIG this year will be looking at the levels, specifically levels of therapy, the reasonableness, and if services were necessary, to make sure that each of the components that go into putting a resident into a resource utilization group were met and appropriately used with that minimum data set tool to ensure that reimbursement is correct for residents of the facility. The next is a new tool that the OIG is developing, the Skilled Nursing Facility Adverse Event Screening Tool. And though will be a new tool and is going to provide some additional information, It relates primarily to a tool there as part of a study that the OIG conducted in 2014. They released and developed a skilled nursing facility adverse event trigger tool, and this is this new tool that they're going to be creating and rolling out this year will help describe and disseminate information about use of that adverse event trigger tool for use by the SNF industry. So I think this will be largely aimed at helping ensure that the adverse event trigger tool previously released is able to be utilized and is beneficial to the industry. The next item that the OIG covered in its work plan for this year is a revision to one of its prior work plan items, and it's regarding the national background checks for long-term care employees, and that there's a mandatory review process. This relates to an Affordable Care Act requirement which granted to the states the ability to implement background checks for prospective long-term care employees and providers. And under the granting provision in the Affordable Care Act, it also required that the OIG conduct an evaluation of that program after the implementation was complete. So for the states that have closed their implementation of that program last year, the OIG is going to be reviewing the procedures that those states use to implement their long-term care background checks and look at the outcomes of the state's programs and also whether those checks led to any unintended consequences. So I would expect that will be something that may be issued as an OIG report as a review of that information, and may directly be an item that, for instance, helps shape if any of those background check requirements are adjusted or potentially proposed to be changed based on the findings. The next item in the work plan is that the skilled nursing facility prospective payment system requirements. And this ties to the Medicare requirement that a beneficiary be an inpatient at a hospital for at least 3 consecutive days before being discharged to be eligible for skilled nursing facility services or SNF services. So and also beyond that, if they were subsequently admitted to a SNF, that they're required to be admitted either 30 days after discharge from the hospital or when it would be medically appropriate to begin an active course of treatment. So in previous years or prior times the OIG has reviewed and looked at this requirement, they had found that some SNFs and Medicare payments to SNFs were not compliant with that 3-day inpatient stay within 30 days of SNF admission. So they're going to be looking at this requirement to see, again, sampling and looking at specific SNFs to see if they are compliant with that requirement. And the final item in the work plan this year that relates to long-term care facilities specifically is potentially avoidable hospitalizations of Medicare and Medicaid eligible nursing facility residents. This is a topic is by no means new and has been avoiding hospitalizations has been on the forefront of much of the long-term care rulemaking and potential rulemaking and review in recent years, and will also be something that was driving, and I'll touch on when we get to the CMS final rule. But specifically for what the OIG will be looking at is they're going to be taking a close look at facilities that have high rates of patient transfers to hospitals for potentially preventable conditions, and looking to see if the services were provided in the facility to residents that may have addressed those conditions prior to the hospitalization becoming necessary, and also looking to see if services were provided in accordance with the residents' care plans, the specific condition that OIG had identified in previous work looking at similar items was UTI, high instances of UTI across residents, and looking to see if, in that instance, if there was prevention and detection services that could have helped, that were either implemented just to show that at least those processes were happening, and if not, addressing why they didn't, as they may have served to help the need to, and prevent the need for hospitalization becoming necessary. So that was the wrap-up of the OIG work plan, and as I said, that's part of the materials that will be sent over. So every year I find that document to be helpful, just again to give the landscape and potential radar for what the OIG will be looking at in the coming year. Now on to the CMS final rule that was issued last fall. So this final rule, and the final rule is titled "The Reform to the Requirements for Long-Term Care Facility," and it's regarding the conditions of participation. So this relates to conditions of participation for facilities that are participating in with Medicare and Medicaid. Therefore, if you are not a facility that serves any Medicare or Medicaid beneficiaries, this rule does not go to the industry as a whole, but rather is an update of the conditions of participation for those providing services to the federal program beneficiaries. This final rule is targeted at reducing unnecessary hospital readmissions and infections, improving the quality of care, and strengthening safety measures for residents in long-term care facilities. So again, the unnecessary hospital readmissions is definitely on the forefront of most of, or many, I would say at least if not most, of the rulemaking and regulation development in the long-term care realm for many recent years. The final rule was published in the Federal Register on October 4th of 2016, and this is the first comprehensive change to their conditions of participation for long-term care facilities since 1991. So this is, again, as I mentioned, the final rule is very lengthy and with a lot of commentary, but that's definitely in large part due to the fact that this is a very comprehensive look at the conditions of participation rather than updates that have happened since 1991, which have been more piecemeal and looking at specific conditions or putting regulations for specific topics into the long-term care realm. The regulations under the final rule, or the regulations as a whole, became effective on November 28, 2016. But the implementation of those can occur in phases, and I think from both talking with people in the industry and also just even how the final rule reads, not only can implementation occur in phases, I think probably the majority of cases they definitely will occur in phases. Those phases are still set to certain timelines, however. Phase 1, and I'll go into, as we're talking through what the final rule encompassed, I'll call out where I can the items that go into these different phases. But the items and pieces addressed for Phase 1, those, the implementation and effect of those was on November 28, 2016. Phase 2 is by November 28, 2017. And then Phase 3 is November 28, 2018. So over the course of a 2-year window, really, but with 3 different deadlines is when these different phases will be implemented. This is a summary of, and I'm going to get into more of what the specifics are, but generally the topics that are covered in the purposes of the final rule were to strengthen the rights of long-term care facility residents. One of those that I'm going to talk to more in detail is that the final rule prohibits the use of pre-dispute binding arbitration agreements, which is currently enjoined and not in effect, but we'll go into that later. In ensuring that long-term care facility staff members are trained on caring for residents. Ensuring that long-term care facilities take into consideration health of residents when making decisions on kinds and levels of staffing they need that are needed at facilities. Ensuring that staff members have the right skill set and competencies to provide person-centered care to residents. And a piece of that, again, we'll focus on this more in a few slides, but having care plans that are both established in certain time frames and have certain components, but are also developed with the residents as a part of the care team and part of the group that helps develop that care plan. Improving care planning, which includes discharge planning for residents with involvement in the facility's interdisciplinary team. Some changes also to who will be on the interdisciplinary team are part of that change. Also, a strengthened focus on giving residents information they need for follow-up after discharge, and to continue whatever services and follow-up items they may need after discharge. Some changes in services and abilities for delegation of services. So now dietitians and therapy providers are allowed to, or have the authority to write orders in their area of expertise when they're delegated that responsibility by a physician, and state licensing law allows. So I'd highlight that's one, and I'll go into this in greater detail as well in a few slides, but specifically physician delegation and what can be delegated by a physician and to what other licensed or trained personnel or professionals can have those delegations is going to be a matter that varies with the state you're in. So as a general rule, some of that delegation is now allowed, but before you as a facility or a provider implement that item specifically, definitely highlight or put a star next to that one that you want to check and make sure that you're not going to find yourself in a situation where the physician has delegated not in accordance with all, their state licensing requirements, which could separately subject them to discipline or some action if not done correctly. The final rule talks about updates to the facilities' infection prevention and control programs, and different levels and components that need to go into those plans. So now I'm going to jump into, and one thing, and I might actually, I have it pulled up handy, and the CMS is actually, they've so far done a few different educational calls and provided some resources on the rollout of the final rule. Many of those materials, the calls have been helpful to join into, so I would recommend that if you are interested and want to stay up on recent developments and how CMS is helping providers implement the changes, go to CMS's website, and it's their MLN Connects portion of their program that sets up those calls and provides the information, which is the Medicare Learning Network. One of the calls specifically had a presentation that went along with it that rolled out and had very specific details on condition of participation by specific condition by condition of what the regulation is, what the changes are, and how to implement those changes. One piece of that presentation, and I'll probably just include a link to that or include that with the materials as well, or at least to the phases, because I find the phase breakdown to be a very helpful resource, is that in that presentation, CMS broke out the phase implementations. So they specifically on a couple pages broke down phase 1, things that will be implemented or need to be implemented in phase 1, and also designated some of the items that will be implemented probably across the phases, but have to be started. The primary implementation has to be started in phase 1. And then also the items that are in phase 2 and phase 3, and again, within phase 2 and phase 3, indicated those items that if they, for instance, have to start in phase 2, but are expected to be something that continues to be implemented through stage 3 and beyond, or also even in stage 3, but are expected to continue beyond that, they're called out there. So might be a helpful resource, especially if you're working with a facility in helping to get these different items implemented. Almost could just turn that into a checklist, or at least something that you're reviewing ahead of those deadlines to make sure that you're on track to meet, to have already started on the things for phase 1, getting ready for phase 2 in this coming year, and then phase 3 the year after. So also include that in materials. Did want to jump over to go into some of the specifics of what these changes in the final rule are. And one of the topics, as I mentioned, was care plans and care planning. The focus in these changes, in large part, is to emphasize the person-centered care and include the resident as a member of the team that is putting in place and then continually monitoring, reassessing, tweaking or changing it as needed the care plan for the resident, and making residents really partners in their care while they're in a facility. One of the requirements now is that facilities must develop and implement a baseline care plan within 48 hours of admission for each resident, and that the care plan must include instructions for person-centered and effective care, meeting the professional standards of quality care. Also, separate from the care plan, but or distinct, I would say, from the care plan, but part of the care plan process. Facilities must also be developing and implementing discharge planning processes, and especially focusing on post-discharge care, preventing readmission, helping residents transition, and also working with whatever the residents' goals may be post-transition. And expansion of the team that is involved in doing these activities has also been included. So now food and nutrition services staff are required as part of the team. Nurse aides are part of the team. So really should now have care plans being developed by most, I would say, a large amount, if not in many cases all, of the facility staff that is working with a resident. And also, as it is very central here, to include the resident as well. Next item. Another big focus here is, and still sort of goes to the broader concept of person-centered care and some active involvement by residents in their care, is specific items regarding resident rights. There now is the ability, facilities cannot have residents waive liability for losses of personal property on a forward-looking basis. There's also similar but separately called out in the final rule, can't have residents waive liability for denture loss or damage when there's facility responsibility for those items. The discharge planning that's talked about up above in the care planning section must also include make sure that residents are discharged with appropriate documentation and information so that they can transition the resident's care, or the resident is able to utilize or to implement and understand their next steps with, either independently or with caretakers or in their next care setting if they're being discharged to another facility or another setting. The resident rights also now include that facilities must assist with application for dental reimbursement where that's something that a resident is entitled to or has coverage for under their beneficiary status. And also in the resident rights category, but again, we'll be focusing on this one specifically a little bit later, the final rule does ban and calls out that there may be no pre-dispute arbitration agreements, but that's currently enjoined by court order, so that one is not in effect right now. And most of these items on both the care planning and resident rights are things that are effective now and at least need to be, are effective now in the sense of the things like the baseline care plan, discharge planning, how that needs to work, interdisciplinary team, but also the ongoing focus for the patient-centered care. That's something that is effective now, but one of the items that CMS had called out as an ongoing implementation process likely started now, but continuing probably through the next couple phases and beyond. Another area of focus in the final rule is assessments, training, and physical environment. So this is to help or is aimed at assessing and strengthening the actual the facility surroundings, operations, kind of day-to-day facility operations. So the phase one requirement of this piece of the final rule is that the facility needs to be conducting and annually reviewing a facility-wide assessment, looking at day-to-day operations and emergencies, examining the resources that the facility has or may need to address care during regular operations and emergency situations. The final rule calls out what what the assessment needs to look at in terms of population, resources, that all the different components that need to go into the assessment. And there are some new requirements for facilities that are constructed, reconstructed, or newly certified after the effective date of the rule, so November 28, 2016. So if you're a facility that is in that category, just call out to you to specifically be mindful that there are some new requirements if you're a new or newly certified or reconstructed facility. Those are not things that go back and have to be changed structurally to previously certified facilities. But it's one, there's only a few instances like that where there's things that are either grandfathered back or only apply to facilities going forward. Also in this section, there's there has to be additional training, and this is something that the final rule discusses certain pieces of the training being implemented in phase 3, and one that CMS calls out in that timeline that I mentioned as something that's in phase 3 with a note that it will be partially implemented in other phases. Specifically, that will expand various subjects that staff is trained on, and actually requires facilities to first determine what training and how much is appropriate for staff of different classification, different type, different level of interaction with patients, resulting from that assessment that the facility has previously done in phase 1. So there's not going to be a one-size-fits-all for that training, and it is something that has to, in part, be a result and action taken from that facility-wide assessment. But this is an area that when I've been talking with facilities, to the extent that the training process and planning for that training, whether it's actually conducting the training or just planning for it, can start ahead of phase 3. I see benefit to doing that as soon as is reasonable and feasible resource-wise and everything else, but definitely not something that there's a need to wait till phase 3 if the facility can start that training planning and or the training processes before that. The next major category of items that are addressed in the final rule is compliance and quality measures. This talks to, and some of the items here are broken down in different phases as well. Many of these quality pieces are in phase 1, or at least will start their implementation in phase 1. So looking to see and ensuring that residents their care plans and then the implementation of those care plans are being done in compliance with professional standards and in compliance with the care plans established. Then also in phase 1, looking at things for this piece like the quality of life. CMS calls them out as quality of life and quality of care differently, but really we'll be focused on looking at retrospectively at a resident's course of treatment or course of stay in a facility and ensuring that that matched up with the care plan established and the professional standards that should have been looked at in that. There are also going to be changes that need to be implemented in facility compliance plans. So something that as facilities are, as you're reviewing or going back to your compliance plan, this is something that's actually called out across the phases, I believe, at least in 2 and 3. Well, and actually, yeah, it's going to be touched on in all the phases. But making sure that your compliance plan is up to date. So having, and includes now all the requirements for the conditions of participation. So looking to specifically have investigations on allegations of abusive conduct, not employing certain individuals if they've had certain actions taken against their licensure. There's several new things that many facilities I think will already have in their compliance plans or have addressed those topics, but now are required. So especially as you're hopefully updating or reviewing your compliance plan annually or more frequently as needed, the next time that you do that, if you haven't done, I would suggest you do it as soon as possible if you haven't done that since this rule went into effect, but also when you do that the next go around, if you have a scheduled time frame for those activities, definitely ensure that you're including everything from the final rule on the compliance plan requirements and specifically addressing and updating those as you move through the different phases of implementing some of the other pieces that tie to quality and compliance. Then also there's 2 new types of programs that must be implemented by facilities. Again, some facilities I think, or many facilities I think and know, have these types of programs already in place. So if you have infection control programs, you have quality assurance plan programs in place, more will just need to be making sure that the program and plan that you have in place complies with the updated conditions of participation under the final rule. The infection prevention and control programs need to be implemented in phase 1, and then by phase 3, an infection control preventionist needs to be designated per facility under that plan. In phase 2, and phase 2 also has a component of the infection control. In that phase, the facility must do their facility assessment and antibiotic stewardship component. So that's one that if you have a plan, again, hopefully many of these items are already going to be addressed, and you can just ensure compliance or adjust them as needed. If you don't have a plan currently in place, or you did not prior to phase 1, should have started that program by November 28th of 2016, but have the next couple phase time periods to build that out completely to get the different requirements met by November 2018 when phase 3 concludes. Also now a requirement for facilities to have developed a quality assurance and performance improvement program. So that needs to be focusing on the outcomes of care, quality of life, systems of care, monitoring care, evaluating performance, and for phase 1 under the quality assurance piece, this is again one that has different components in each phase. The quality assurance and performance improvement for phase 1 was to establish your quality assurance committee. In phase 2, it's to get the full plan built out for your quality assurance and performance improvement. And then for phase 3, it's to actually be implementing that. So like with the training component, this is another one where if you have this program or it's something that you're beginning to develop, definitely no need to wait to roll all these, to meet the final implementation piece until phase 3, and you're well served to do that as soon as you can, but it is described to allow for the flexibility and time involved to be rolled out during phase 1, 2, and 3. And then the final large section of the final rule or breakdown I'm going to talk about is covering facility services. So this covers actually a broad amount of different items, but as I mentioned, there is now the ability for, in certain cases, physicians to delegate for therapy and for dietary items, the ability to be writing those orders to the qualified clinical personnel that are allowed, that have that licensed ability, and again, make sure you're doing so in compliance with state law. Also, there is now a competency requirement, so to determine sufficiency of nursing staff, and that's going to be tied to the facility assessment that the facility-wide assessment that I mentioned above. So that both for nursing staff, actually there's also a direct tie from that. We'll be looking at the administration of the facility as well. So after the facility assessment is done, reviewing the different levels of staffing, competency, and that all will tie to the specific makeup of the facility. So again, not one size fits all. It'll look at number of beds, / number of residents, range of diagnoses, acuity levels, the care plans implemented. It's going to take into account all the things that are reviewed in the facility-wide assessment. The other item that is going to be, another item that's going to be called out under the services piece is that pharmacists at facilities are also have a development, or excuse me, a requirement now to, with regulations that help reduce or eliminate the need for psychotropic drugs with patients. So that's an area where if you are a pharmacist at a facility or you are working with a pharmacist, that specific piece goes to pharmacy and drugs in the facility. And then finally, there's also the requirement, and this is one called out in phase 1 as well, is that residents also are entitled to, or the facility is required to provide, and it sort of speaks to the resident rights as well, I suppose, but that residents receive nourishing, palatable, balanced diets meeting their needs, and to achieve that end, the facility needs to ensure that its staffing is sufficient on the nutrition front and the dietary front to be able to provide those services and to address resident preferences, match up with individual care plans, that sort of thing. So a lot of these, though they can be broken down into the various categories, you're probably putting together that they relate very much to one another across these different sections. And most of the items I would say as general topics go back to either the concept of patient-centered care, and resident involvement in their care, and also results that will come from the facility-wide assessment and looking at almost all aspects of what the facility provides to residents, its administration, kind of top to bottom of where the facility is at the time of that assessment, and then items that need to change based on that assessment as the other phases roll out. Oh, and sorry, this one I was almost going to skip over that. As a phase 2 piece, another item in that is that by the implementation date for phase 2, the necessary behavioral health care and services must also be provided to residents, again, in accordance with the care plan developed and such. But that's also by phase 2. Okay, and finally, going to talk a little bit about the developments, including recent developments just earlier this month, on the status of the pre-dispute arbitration ban that's in the final rule and where that stands in the court system. So, and probably as many of you listening are aware, in any relation you've had with long-term care facilities, facilities have historically favored agreements to arbitrate at the time of admission, or pre-dispute agreements to arbitrate with residents of their facilities. The reasons for that usually include that the decisions of arbitrators will be final and binding, or have in most cases, very limited routes to be reviewed and bases that they can be reviewed and reopened by courts. So give finality to the agreement or to the decision. They're thought of in many cases as being more efficient from a timing purpose, that they can be done more quickly, and also that they are less costly than going through regular litigation in court proceedings. The Federal Arbitration Act is not specific to healthcare at all, but it's separately a federal law, the FAA, that provides that agreements to arbitrate are presumptively enforceable. So going into a commercial agreement, two parties can make an agreement up front that they will arbitrate any dispute that arises between them. There has been case law, including Supreme Court case law, that has looked at specifically arbitration agreements in the long-term care context. And there's the Supreme Court case from 2012 that it found that the FAA preempted a state public policy and state enforcement of a prohibition on arbitration clauses in nursing home admissions. And that was specifically to that it would be contrary to the FAA, and that categorically prohibiting arbitration of a particular type of claim. So in this case, categorically prohibiting nursing home admission agreement pre-dispute arbitration was contrary to the FAA. So in the final rule issued by CMS that we've been talking about, the final rule does provide a ban on pre-dispute arbitration agreements. So it prohibits facilities from entering into or requiring any arbitration agreement as a condition of participation. This is an item in the final rule that's called out as being prospective, so it would not have the effect of, if this ban or if this part of the rule ultimately stands and continues, even in that event, it would only apply to admission or any potential agreement from the date of the final rule forward. So only talking about November 28, 2016 on, under no, in any way that the court cases shake out, the final rule does not call for this to go back in time. So agreements that are in place to arbitrate before the final rule still, they're grandfathered in and would still be, subject to the same interpretation that they had before this final rule. This ban and the final rule, again, only applies to federal beneficiaries because these are speaking to the conditions of participation in Medicare and Medicaid. So if a facility does not serve federal reimbursement beneficiaries, then the final rule doesn't apply, so that this ban would not be speaking to those types of facilities. And also another item that was interesting, or is interesting, I think, in the final rule, or worth mentioning and of note, is even if the pre-dispute arbitration ban is upheld ultimately and continues, there is no ban and doesn't apply to post-dispute arbitration agreements with certain conditions, if certain conditions are met. So that means that if a dispute arises between a facility and a resident, the facility at that time can ask a resident or their representative to sign, to enter into an arbitration agreement and to have the dispute resolved by arbitration. That's fine, as long as the resident or the representative understands and acknowledges that they understand the agreement, that the agreement is entered voluntarily, provides for selection of a neutral arbitrator agreed by both parties, and provides for a venue convenient to both parties. In that instance, can't tie to the resident's ability and right to stay in the facility, can't contain any language that would prohibit the resident from communicating with any regulators or officials on the state or federal level, can be signed by another individual if state law permits that and if the individual has no interest in the facility, and if a resident in a facility agree to resolve a dispute by arbitration, that agreement plus the arbitration decision must be kept by the facility for 5 years and open to inspection by CMS. So would still, again, even if the ban on pre-dispute agreements were to stand, still can have arbitration agreements upon a dispute arising, but have to make sure that you're meeting those conditions. So the way that the pre-dispute arbitration ban has proceeded through the court system, the American Healthcare Association and some other plaintiffs filed suit challenging that ban in the Northern District of Mississippi in November, beginning of November. And I'm sorry, it was in October. They filed that in October, and the injunction was issued in November. The case is called American Healthcare Association versus Burwell, and that's the Secretary of Health and Human Services. And the allegations made in that case, the defendants are claiming that the ban violates the FAA, the Federal Arbitration Act, and exceeds the authority that CMS has under the Social Security Act to implement rules or to engage in the rulemaking process. The defendants were seeking declaratory and injunctive relief to prohibit that ban from going into effect until the court can consider the merits of their claim. That court did issue an injunction on November 7th, 2016, and that injunction prohibits the ban on pre-arbitration agreements being effective so long as that injunction stands until the case moves forward and there's a final determination on that. So the ban never went into effect because, again, the final rule was not effective till November 28th. So there was not no time period when it was in effect. The oral arguments for the case are expected in July of 2017 at this point in time, so in several months. We'll see how that progresses as other intervening things may happen. And I note that because following the injunction, CMS issued a memo to in the line of people, its surveyors that are looking at facilities for compliance with the conditions of participation, and generally stating that it will not be enforcing the ban while the injunction is in place, and its surveyors should not be considering that item as a condition of participation when looking at facilities. Most recently, CMS filed a notice of appeal with the Fifth Circuit on just January 5th, so earlier this month, appealing that district court decision to issue the injunction. So, and one element that's unknown on that piece is the government does have the ability to ask that appeal be expedited, but as you probably can tell from the timing, that it was filed before the change in administration. So don't know now what, if the government action in terms of asking for that to be expedited or proceeding may change or may remain the same. But currently there is a notice of appeal filed. However, that notice of appeal doesn't change the status and effectiveness of the injunction. So long as that injunction remains in effect and the appellate court has not overturned that injunction, the ban is not in effect, it remains enjoined, and we'll have to see how that plays out through the appeal process. So thanks for joining us today. I know there's a lot of information we covered, and hopefully the resources that we'll send with the presentation will be helpful both for you to use now and also keep or bookmark as you're implementing the different phases of these changed conditions of participation over the next couple of years. If you are looking for additional resources, like again, our healthcare blog has, internally with Hollard & Hart, we have additional information on our blog under the publications section. We have future webinars coming up on other healthcare law topics. Other additional resources, again, specific to this topic, I would say that the best CMS resource, again, is the MLN Connects, the Medicare Learning Network. They're just checking back with that periodically to see when they've scheduled their next call or informational session addressing some of these topics, and I think that, or I would expect that there will be more of those as the phases continue to roll out. And once again, if you have any questions, feel free to drop me an email or give me a call. Happy to help and touch base if you have any questions on sorting through this. And I would expect when we do see additional guidance on the litigation about the pre-arbitration ban, we'll be doing some follow-up information to to send out to everybody what the status of that is or how things are developing. Thanks very much for joining us today, and have a great rest of your afternoon. Bye.